Trump's defense lawyer details the indictment. He got the summons for us. We've got some rumors about what the charges are, and the maximum penalties are pretty severe. Doing some quick math on this, it's 100 years. Now, James Trusty, Trump's lawyer, is giving us some insight as to what this means. And he detailed for us 3 different charges. 18 U.S. Code 793 we'll take a look at. We've also got tampering and some reaction from Trump's other lawyer, Tim Parlatore. And then we've got false statements and conspiracy charges that we'll review, along with some evidence from CNN, allegedly from a recording that we think may be from this guy, which is a former Trump valet, Trump personal assistant, called Walt Naudo. And so let's listen to what Trump's attorney details for us. What does this summons entail? Jim Trusty from Trump's defense explains.
Now, we haven't been provided with the indictment yet. What we have right now is essentially a summons, which is a replacement for a warrant, right? Normally, indictments are accompanied by a warrant where there's an arrest. Here, we've received a summons from the Department of Justice asking us to be at the courthouse Tuesday at 3 o'clock.
And does it say how many charges there are against your client?
It doesn't perfectly mirror an indictment, but it does have some language in it that suggests what the 7 charges would be. Not 100% clear that all of those are separate charges, but they basically break out from an Espionage Act charge, which is ludicrous under the facts of this case, and I can certainly explain it, and several obstruction-based type charges, and then false statement charges, which are actually, again, kind of a crazy stretch just from the facts as we know it. So there's a lot to pick at eventually from the defense side, but that appears to be the charges, and it appears to be something that will get off the ground on Tuesday.
Okay, so you're confirming it is 7 charges. You said there's an Espionage Act charge. Is there one on the willful retention of documents?
Yeah, that's it. We're talking 18 U.S.C. 793. And then there's several 18 U.S.C. 1512, 1519. I know it's great television, right, to cite these numbers. But the bottom line is it breaks down to the retention charge, as you would call it, obstructions, and false statement.
And is there a conspiracy charge in here?
I believe so. I don't have it in front of me right now. Again, this is not biblically accurate because I'm not looking at a charging document. I'm looking at a summary sheet. So there's language in there that might actually be reflecting a single count instead of 2, but I think there was a conspiracy count as well.
And so that means there could be other indictments. Have you been told that anyone else was indicted here?
We weren't advised of anyone else being indicted. I have a theory that maybe some of the outrageous misconduct has affected the equation in some other case, potential target. But bottom line is right now all we know about is our client.
What's your theory?
Well, over the last 24 hours, it's become public that members of the Department of Justice, led by Jay Bratt, who is a pivotal figure in this investigation, this is the guy who wanted to do a raid before they even had a subpoena out, he apparently, along with 5 other people in his presence from DOJ, extorted a very well-respected, very intelligent lawyer from Washington, D.C.
Caitlin doesn't like
saying
that.
Essentially, if you want this judgeship that's on Joe Biden's desk, you have to flip your guy to cooperate against the President of the United States. That should be a headline.
Do you have evidence of that? I know
that
that's been something that Republican allies of Trump have been saying, but do you have evidence that happened?
Proof?
Yeah, this is...
Yeah, we do.
This is no political talker. This is something that was reported at the time by the attorney. It has been basically sworn to by him. He's written a letter that's been submitted to a U.S. District Court judge confirming it happened. And I think it'll be really interesting to find out whether DOJ, whether the 5 people that sat in the room and watched that extortion have threads of text messages or emails where they comment about that. So we're going to want some discovery about just how far-ranging this criminal activity was by a prosecutor. And think of the irony. Once again, you've got prosecutors saying, we're going after this guy because of obstruction. You know, that's their theoretical distinction from Delaware, while they literally obstructed justice. They literally tampered with a witness in the fall of 2022.
Let's get back to the indictment here. We don't have any evidence of what you're claiming there. I know that the legal team has been alleging prosecutorial.
Yeah, just sworn testimony.
That's what you're saying. I'm taking you at your word on that. We don't have any evidence of that ourselves. I just want to note for our audience. But I want to get back to the indictment here because this is the breaking news tonight from your own client. How did you find out about this? Did you hear from the special counsel, Jack Smith? How did you get this summons that you're referencing?
We got an email from the guy who actually did the extortion. I think that was a cute little message from DOJ that they're not going to worry about their own dirty house. And so we got an email that basically had a summons, an invitation to have a call to kind of work on some of the logistics. And we'll work on those logistics. There's a lot to kind of figure out between the U.S. Marshals and the U.S. Secret Service to make this as smooth as possible, make it safe for the public, and make it efficient in the courthouse. So that's all coming. It would be nice to actually have a copy of the indictment, but we don't have that quite yet.
When do you expect that you'll get
a hostage until we agree?
When do you expect you'll get a copy of that indictment?
Sometime between now and Tuesday afternoon. If they want to continue to play games, they'll give it to us at 3:01 p.m. Tuesday.
What was the former president's reaction when you told him that he had been indicted in this case?
Yeah, it's a combination of things. I mean, look, anytime you advise a client that they've been indicted, when they know it's just fundamentally wrong, you know, I know all attorneys go on the air and say, my client's innocent, and then after the trial, we're going to win the appeal. Well, here he is innocent. I mean, everything about this case is absolutely rotten. The misconduct that we've documented for an attorney general who hides behind Jack Smith. And so his reaction was personal, but it wasn't. You know, he thought about it and he said, this is just a sad day. I can't believe I've been indicted. You know, those are kind of my summary words of what he had to say. But at the same time, he immediately recognizes the historic nature of this. This is crossing the Rubicon. You know, when we have a weaponized DOJ serving as the Praetorian Guard for the Democratic Party, for the incumbent administration, and the attorney general, who is in charge of Jack Smith, hides from meetings, hides from conversations, and just says, go talk to Jack.
Well, Jack Smith
is a crazy new world.
Jack Smith is a special counsel. He acts independent. That's why he was appointed in this. But he was in that meeting that you were in on Monday at the Justice Department, we are told. Did he say anything to you in that meeting? Was there any indication that these charges were coming?
Now, I'm not going to talk about the meeting, but to go back to your premise there, Caitlin, this is not an independent counsel statute. That changed. This is special counsel. They are still answerable to the Attorney General. Now, for whatever political reason, maybe it's all about Delaware, where apparently cases go to die, everything that the Attorney General should be doing in terms of transparency is not happening. That started with his impromptu press conference to announce the president's guilt. It's continued with the misconduct that we've documented, and it's not just the smoking gun that I've mentioned in terms of extortion. Now, obviously, you got Tim Parlatore there. He can tell you about the grand jury abuse that he went through directly. That's pretty solid evidence.
He's good, man.
And there's a whole bunch of other stories of mistreating, intimidating, browbeating witnesses, and gamesmanship. So
I know those are your allegations.
We're going to come out smoking on
Jim,
this thing.
And I know that's why you went to the Justice Department on Monday to air your grievances about how this investigation has been conducted. But again, this is historic. You're right. Your client has been indicted. He's the first former president to face federal charges. What day did you get the target letter letting you know that he was indeed a target in this investigation?
Let me just put it to you this way. Witnesses don't have raids at their houses, okay? We've known he's a target.
But when did you get the formal letter? Because that changes it.
I'm not going to get into that. The internal communication stuff is not something I'm comfortable throwing out because it's between the attorneys, okay?
Well, you feel comfortable coming on and making these allegations. But, Jim, you feel comfortable making these allegations about who's on the special counsel's team. Why can't you say when they sent you the target letter?
Because I have no interest in reporting on those types of facts of communication. So, sorry.
Which legal team will be with Trump when he shows up on Tuesday? Will he show up on Tuesday?
Yeah, he's going to show up. Look, he knows he's innocent. He knows this is garbage. He knows there's fundamental flaws with each one of the counts that they're apparently putting in this indictment. And he knows that the whole process, starting from the archivist, was a corrupt and politicized one. So he's not shrinking from the fight. He's disappointed that this is where we are as a country and this is where the Department of Justice is. But he's not, you're not going to see him, hide in Scotland. He's going to be ready to handle this case and help his attorneys fight it. We'll see. It'll make some excitement to see who shows up at the table on Tuesday, I guess.
So it's not clear which attorneys will be with him. Is that what you're saying? Because so far it's been you, John Rowley, Lindsay Halligan handling this.
We'll see where it all goes.
Okay, so you're leaving the door open that other attorneys could be joining. We'll see what that looks like. Is your understanding that all of this is now happening only in Florida, not in Washington at the grand jury here any longer?
No, it's definitely happening in Washington.
Yeah, that's a good question. I mean, it's kind of an interesting scenario as to why they would be in a grand jury in Washington, D.C. for the better part of whatever, maybe 10 months or more, and then make this shift. I know that some of the
I think it's to cover up the FD 1023.
Colleagues from the Department of Justice had even published articles talking about some of the venue problems that they might have with some of these charges. But I think it might go back to the misconduct. I think there was so much that was wrong about how they conducted the investigation in D.C. that they might be going down to Florida to kind of sanitize the process, make it look to the Florida grand jury like there's nothing to see here when they drag in vice presidents, violate attorney-client privilege, make 4 personal attorneys and 7 Secret Service agents and a vice president testify. Maybe they're trying to get away from the damage they did in D.C. But bottom line is no sign of a second case or a separate case. That would be kind of the ultimate overreach by the
No sign of a second case. So that's interesting. He's saying that they are trying to rebuild the case in Florida. In other words, they really screwed things up in D.C. So they're going to take a bunch of the evidence that they gathered in D.C. from, violating executive privilege, from breaching attorney-client privilege, from threatening witnesses with removing their judgeships, all that stuff. They're going to take all the evidence from that. They're just going to, sort of pass some of it along down to the Florida grand jury where it hasn't been tainted, and rebuild a case that's free from all of the fruit of the poisonous tree that the government created in their original prosecution. Meanwhile, we heard a couple of the charges from James Trusty, and this is what he explained for us. 18 U.S. Code 793 was one of the charges that he referenced. And so very briefly, I wanted to show you one particular statute here, which I think might be pertinent, which is subsection D, right? This is what they might be saying Trump did. And this is from 18 U.S. Code 793, which is gathering, transmitting, losing defense information. And we have this one under the espionage category. There's also the obstruction category, and there's also the false statement category and the conspiracy category. All right, so these are very big statutes, and I just wanted to show you how broad they are, essentially. Here they tell us, under subsection D, that this would be Trump, all right, Trump essentially, lawfully having possession of access to these documents, anything relating to national defense, and if you have reason, if the possessor has reason to believe that it could be used to injure the United States, if they communicate, deliver, transmit, or, here it is, willfully retains the same, okay, and fails to deliver it on demand, is in violation of this law. So it's not a complicated thing. It's just if you willfully retain something and you fail to deliver it on demand to an employee of the United States who's entitled to receive it, that's violation. Now, one of the things I would just latch onto is this right here. Is the National Archives entitled to receive a declassified document that is a presidential record that's in Trump's possession? I would argue no, you're not entitled to receive it. You're not entitled to receive any of these things. They're Trump's documents. They're his personal records that are not entitled to be withheld and archived as part of the presidential records. And the D.C. Circuit, through Judge Amy Berman, has communicated that in the lawsuit about the Clinton sock drawer. This is just one statute, and you can see there are others. 18 U.S. Code 1519 is about the falsification of records. It says, whoever knowingly alters, destroys, mutilates, conceals, falsifies, and so on, or obstructs the proper administration of any matter of the law shall be imprisoned not more than 20 years. This is a statute that can result in 20 years imprisonment. See how broad these are? We also have tampering. And so we've got some evidence that is now floating around about some of this stuff. But one of these is a big statute about tampering with a witness or a foreign informant. Punishment in a big, long statute, right? And so the government is going to have to prove their case under these charges. But what is the evidence that actually makes these things up? What might espionage be? We just read that. It's willful retention of a document that you know is really not something you should have. Here's what CNN says.
I'll report last week with Caitlin Collins and Caitlin Polans about this recording where the former president not only claims to have retained classified information, but also acknowledges the limits of his power to do so. And now we have the transcript of the relevant portion. And I'll read some parts of that, but it's clear he acknowledges or claims that he kept secret information. Now, in this recording, this was back in July 2021, he is speaking to some visitors at his New Jersey golf club. We know from our sources that among the people in the room were at least two people working on Mark Meadows' autobiography, as well as some Trump aides. He is referring here to General Mark Milley. He says, quote, well, with Milley, let me see that. I'll show you an example. He said that I wanted to attack Iran. Isn't that amazing? I have a big pile of papers. This thing just came up. On the tape, we're told that you can hear him rustling the papers at this point. Look. This was him. They presented me this. This is off the record, but they presented me this. This was him. This was the Defense Department and him. We looked at some. This was him. This wasn't done by me. This was him. I'll keep reading, but you can tell at least 4 times, he emphasizes that this was Milley. He goes on to say all sorts of stuff, pages long. Look.
Milley's not a big friend of Trump, by the way. Remember, after January 6th, Milley and the DOD, they were on the phone with their compatriots in China, and they were also talking with Nancy Pelosi about removing Donald Trump.
Wait a minute. Let's see here. I just found, isn't this amazing? This totally wins my case. And I want to note here, his case he's referring to here is this dispute with Milley, not the current pending criminal investigation. Except it is like highly confidential, secret. This is secret information. Look look at this. I will note that secret and confidential are both, of course, levels of classification. And then arguably the most damning quote, he says, he asks someone in the room if he can declassify it. And then he says, as president, I could have declassified, but now I can't. And of course, that last quote undercutting all of the public arguments that he, his allies, and his attorneys have made about how he was able to declassify things once he left office, or that he may have even had a standing declassification order to declassify any materials in his possession before he left office.
No, it doesn't. It just means that he can't share the information. He knows it's highly secret. He knows it's highly confidential. In other words, it's protected information. So he can't just publicly start talking about it to exonerate his position. It's not that the status of the document is an illegal status. He's not saying here, look, I've got illegal drugs in my possession. He's saying that the characterization of this information is highly confidential. It's secret. He's still not breaking the law by being in possession of classified documents. He's just saying, this is secret stuff. You know, I can't just put this in your book, in other words. But it wins my case. But I am entitled to keep it because it's not a part of the presidential records that need to be archived, except it is like highly confidential secret, he says.
And then arguably the most damning quote, he says, he asks someone in the room if he can declassify it. And then he says, as president, I could have declassified, but now I can't.
In other words, he could have gone through a formal process by which he communicates this information to America through the formal process, but he didn't do that. But that doesn't mean that the status of this document is illegal. There is a declassification process you can go through and all the things, but the fact that Trump is in retention of this doesn't mean that it is illegal. It could still have a declassified status, but he didn't go through the formal declassification process to present it to America. If the president has to fill a form out in order to do something, then the person who's in charge of approving the form is more powerful than the president, okay? I know it's very complicated for these CNN people to understand that.
Investigation, prosecutors are likely going to be most interested in the fact that he is claiming to have retained secret information and is appearing to try to share that with a room full of people, none of whom had security clearances. So again, this is a really key piece of evidence in this.
I don't think so. I think they're mincing his words. They're manipulating his words. I don't think he's saying to somebody, I'm showing you top secret information, top classified information that I can't be showing you. I think he's saying this is information that I have that is technically declassified as a document status, but I cannot give it to you to put it in your book because it is sensitive secret information. So he's actually making a good judgment about it. But they're taking that language and they're rebundling it to say, I've got secret classified information that's top secret and documented, and that's why I'm not giving it to you. It's what prosecutors and the corrupt media do.
Yeah, Paul, this was reading your reporting this morning. It was a genuine kind of jaw-drop moment.
I'm
just
sure
because
it was
of how many things it seemed to rebut about what the president has said publicly. You kind of got at this a little bit, but what is your sense of how this will factor into things going forward or into the indictments that we haven't seen yet?
We were doing our reporting on the existence of this audio recording last week. I mean, one source close to the legal team told me, look, this audio recording, this is a problem. And the former president's legal team only learned about this a few months ago in March when a witness was asked about it before the grand jury. I also want to note that prosecutors subpoenaed the document that he refers to, and they still don't have it. It's unclear, one, what this document was. If it was indeed a real document, though it appears by this transcript, he does clearly think that he's in possession of something, that he is showing them something that supports his argument against Milley. But at this point...
Is it, though? Was it actually illegal? Was he in possession of it? Because the law doesn't say talking about something like that. You've got to actually have the document, right? You got to actually be in possession of it, right?
It's not clear that the government even has this document in its possession. So we don't have the indictment at this point. It's unclear when that will be unsealed, but it would not be surprising if this audio recording or quotes from it come up in the indictment. But at this point, we don't know. It's clearly, though, a piece of evidence that even the former president's legal team acknowledges is a problem for him.
Well, it's a problem because you guys have taken it out of context and you're trying to say that him referencing a highly sensitive document makes that possession of that highly sensitive document illegal. And that's not necessarily the case at all, especially when you give us partial transcripts from some witness. This is a former Trump lawyer, Tim Parlatore, and he's talking about evidence that Trump's other lawyer, Evan Corcoran, may have presented to the grand jury, to the special counsel. And remember that Trump hired a lawyer, and when you hire a lawyer, you have attorney-client privilege to protect those conversations. But the special counsel and the courts have breached that. They've said that that protection no longer applies to Trump and that Evan Corcoran can now testify. So Corcoran did go in and testify. One of the ways that they broke that attorney-client privilege was by alleging that Trump was using this lawyer to commit crimes. And there's what's called a crime fraud exception. You can hire a lawyer and have all sorts of protections and attorney-client privilege. Unless you're committing a crime together, then you don't get to use that force field of attorney-client privilege to protect yourself. So then it breaches that privilege. And now they're asking about this because Trump apparently is being charged with obstruction as well. Now, here's what the story is.
You got to remember, that litigation was done before the prosecutors had access to the actual notes. It was all based on supposition of they want access to the notes to see if they will match their theory. And I think once they got the notes, they realized, wow, it doesn't match our theory at all. And so, based on everything I've seen, if they don't change their theory of obstruction, if they keep with the same, theory that they've been pursuing throughout, Evan Corcoran very well could be a witness in this case, but he'd be a witness for the defense.
So to be clear, you've reviewed the Corcoran notes and these voice memos?
Those are essentially one and the same. It's a transcript. He took voice memos, rather than writing it out.
And to be clear, your assessment is they are not damaging to the former president's case?
Correct.
On what basis?
These are ordinary conversations that an attorney would have with their client who has just received a grand jury subpoena. Questions get asked. It's happened to me hundreds of times.
All the time.
Where a client gets a subpoena and they say, do we have to comply with this? Do we really have to give them everything? Do they have this power? Don't they have to get a judge to approve this? Do we have an opportunity to stop this? Can you file a motion? All of those questions of, do we really need to respond to this?
All are normal. You're allowed to do that. You're allowed to ask questions in American justice, or where you were used to, and pursue your case. It's called the adversarial system. I've had many clients tell me, well, what happens if I don't show up? What happens if I say this? What happens if this person doesn't show up? How does all this work? And you can communicate about that, and you can advise a client, well, if you don't show up, or if you do this, or they do that, here are some of the other consequences of that course of action. So it's all normal, unless it's Donald Trump, right? You're allowed, in my humble opinion, to challenge elections. You're allowed to challenge the Electoral Count Act and say that Pence has powers that maybe other people don't think he does have. That's how the system works. People push the limits and people push back. It's the same system that we see everywhere. The Dobbs decision came out from somebody challenging something in a new novel way that came out with a new opinion from the Supreme Court that then echoed throughout the entire country. Happens every single day. Only this DOJ will say that Trump asking questions and investigating his position in our justice system is akin to criminality and insurrection, and such that it should violate the attorney-client privilege. These people are disgusting. And they are weaponizing every single facet, including the attorney-client privilege, to bring all of these charges against Trump. There are many, and I'm sure there will be more to come. Of course, we will continue to dig into this. Thank you for liking this video wherever you're watching, and thank you for subscribing as we continue to cover this.